I'm delighted to introduce Jennifer Perkins, who is a judge on Division I in the Arizona Court of Appeals. She is also an advisory board member of the LEC and a good friend of the LEC, and we're happy that she can lead us through our first panel and get the 19th Annual Judicial Symposium on Civil Justice Issues launched. With that, Judge Perkins.
Thank you, Don, and thank you all. Yes, I expect a high-level litigator like Mark to be able to take the list of subjects I gave him 10 minutes ago and go full bore. So here we go. This is the fun panel, Emerging Issues. Experienced attendees will keenly miss John's presence on this panel. This is my first time at this particular symposium, but I've heard tell that Bob and John usually have a great conversation. So Mark and I will do our best to facilitate that. We don't do lengthy introductions, thankfully, since I just met Mark. Bob is the founder and president of the Center for Constitutional Litigation. Mark is a partner, and I actually don't know in what section of Shakardi.
I co-chair the public policy group at Shakardi.
Great, you'll have some excellent policy-based contributions. So John and Bob had kind of allocated our time to 4 particular areas. We, of course, would love to have conversation about different emerging issues. This is freewheeling, so, jump in with whatever you think is interesting. But we're going to focus the time first on these 4 areas. First, the apparent disappearance of the civil jury trial. Should courts and practitioners care about that disappearance? Do you agree that there is a disappearance of the civil jury trial? Recent state-level moves toward non-attorney ownership of law firms, including my home state, Arizona's Alternative Business Structure Program, and are there potential ramifications for the civil justice system? The ever-present AI issue. It wouldn't be an emerging issues panel without talking about AI. How should courts deal with briefs that appear to be presenting a reliance or perhaps an over-reliance on AI? Public confidence in and respect for our judicial system. Is it disappearing? Why do we think yes or no on that? So I think we had anticipated introductory remarks by both. Bob, I'm going to ask you to go ahead and get started how you'd like, and maybe we'll just proceed with more of a conversational style on each of those. So take it away, Bob.
Thank you, Your Honor. It's a pleasure to be here once again, and I thank the Law and Economics Center for inviting me. In fact, it was LEC that originally introduced me to Victor Schwartz. And so if you don't mind, I'm going to tell a little story, because we used to get together on this platform before LEC was associated with George Mason and do debates. And we did them with great frequency. And there was one time in which we were going to be doing this debate before a judicial audience at the Brookings Institution. And Victor not only was erudite about the law, but he also had an uncommon ability to imitate various politicians. And he would work that into his remarks. And I had gotten used to basically when he would do so and how he would do so during the course of this. So this one instance in which we were debating at the Brookings Institution, there was a great rainstorm and he was late. And there was a decision made that we would go ahead, and when he showed up, he would go ahead. And the way that Victor and I had worked this out was he was going to go first, and then I would do a rebuttal, and then he would respond. So I didn't have something to rebut. And so instead, what I did is, well, if Victor was here, he would say this. And at this point, he would then imitate Arlen Specter. And then at this point, he would say this, and he would do this. And this is why all that was wrong. And so he arrived just as I finished. Ran up to the stage, apologized for being late, and then did exactly as I said. Was getting the biggest laughs, he told me later, that he ever did, and he had no clue why it was working so well that day. So, anyway. So let me start with jury trials, okay? And The fact is that juries have been maligned almost from the beginning. There is remarks that were made in the 1960s by Erwin Griswold, former dean of Harvard. He was also Solicitor General. He was somewhat of a grouchy type of person because, for instance, one time when he was invited to the Supreme Court to take a picture with two of his former students who were on the court, Justices Souter and Kennedy, he was asked, was he surprised that two of his former students would be on the Supreme Court? He said, no, it's just I didn't expect it to be these two. And so, with respect to the jury trial, his question was, why would anyone think that 12 people brought in from the street have any special capacity to decide controversies between persons? This was a sentiment that's been frequently expressed. In fact, Charles Evans used to say, well, I don't even understand why we have juries. He goes, judges are the epitome of justice. And so there was this bias against juries that has been essentially age-old. But the fact is that empirical studies show juries do a remarkably good job, that they really do listen to the evidence, they do follow the instructions, they do their level best to come up with a fair verdict based on what they heard. But we've been hearing about the vanishing jury for almost a century at this point. In 1962, the Administrative Office of the Courts for the United States courts started keeping statistics. And in 1962, 6% of civil cases before federal judges were before juries. A federal judge usually handled at least 10 civil jury trials a year. By 2024, it was 1% of civil cases. And a federal judge would be lucky to have one jury trial a year. The diminishing use of juries also began in criminal cases. In 2024, the average federal judge had 2 criminal jury cases, and that's largely because of plea bargaining accounts for 90% of criminal cases. So why have jury trials? Well, besides the fact that it's in the Constitution and the Constitution of 48 of the 50 states, at least for civil cases, what you have is a certain amount of legitimacy. So this rolls in a little bit into the public confidence issue because juries give courts legitimacy. We don't see over-aggressive government essentially telling people how they are supposed to live, how their controversies get decided. Instead, there's a certain amount of confidence that when juries are essentially interspersed into this system, they get to really have their day in court. It was one of the grievances of the Declaration of Independence that we were being denied by the king of jury trials as cases were being shifted into admiralty court where there were no juries. It's a safeguard against government overreach, and it also advances democratic values. Studies show that once someone has served on a jury, their frequency of voting increases. That this is something where they feel that they've got a stake in the system, they have a closer understanding at least of some aspects of government, and it causes them to want to vote in greater numbers than they did before. And it's an investment in the courts. It shows people that they need not be helpless, that the courts are there to provide a answer, a disposition to their disputes, and do so in a peaceful manner that might not otherwise occur. And as I said, it increases public confidence. Now, why have we had a diminishment of jury trials? Well, there's mandatory arbitration, there's legislated limits on jury trials, there's pressure to move cases along, and certainly juries take time and effort. And there's the backlog in the courts and the pressure to make sure that everyone gets their cases heard. So that's the pressure. But the fact of the matter is also we're going to see some other problems in trying to re-establish the jury trial. And that's because with so few jury trials, there are going to be fewer attorneys experienced with jury trials who are going to then want to opt and tell their clients that a jury trial is a good thing because they just don't have the experience, they don't have the skill set that might be necessary for a jury trial. And so that's another part of the question in which legal education really needs to play a part, but also we need more jury trials so that we have the tools that make jury trials possible.
So I'm gonna, this is still a little bit early in the morning, especially for us West Coast people. Little audience participation here. Can I have those folks who sit in a trial level court and who could have heard a civil jury trial in the last year? How many of you have presided over a civil jury trial in the last year?
That's great.
All right, so that's actually a better response than I thought. What do you think, Mark? Have you had an opportunity recently?
Well, can you hear me okay? I'm so loud. You can probably hear me without the mic. That's what my wife would say, at least. Anyway,
Your mic's not on.
it's not on. You can still hear me.
Oh, that's
There you
great.
go.
I had an opportunity a few years ago, actually, to serve on a murder trial in the District of Columbia, and it really helped me understand how significant juries are and really have faith in the system. It was an interesting case. I'll go on a side, but it was a drug deal gone bad. It was clear that the defendant had committed the murder, and we had a very diverse, a perfectly diverse jury, half split between black and white, men and women, all different age groups. And everybody came together, and we had a couple of jurors that just would not convict. And it was, I think, because they were concerned that this fellow had done this, but it was a 19-year-old man, and I think they were concerned about sending another 19-year-old away for the rest of his life in what had been a drug deal gone bad. And I think there was a realization, and we talked about this, that if he had not taken out the guy that ripped him off, he was going to be killed himself. And he was put in literally a prisoner's dilemma. Do I take this guy out, or do I get killed for the deal? And he did what he had to do under this circumstance. And it was remarkable because people understood, this predicament this fellow was in, but he had still committed a very serious crime. He'd taken somebody else's life. And the jury said, these two ladies said, I don't know if I can do murder one, but what's second-degree murder? And then they asked the judge to read, and then they came back and they said, the foreman said, do you think you could agree to that? And they said, yeah, I think we could do that. And then very quickly, within like 15 minutes, the jury came together and reached a result. And it was remarkable because it was justice. It wasn't following the law, because if you followed the jury instruction, it would have been murder one. It would have been. But everybody understood that this wasn't a case of he broke into a stranger's home, he shot some random person on the street. And so anyway, from my own personal experience there, I just came away with a remarkable respect for how the system worked to reach a just result. So anyway, why do we have the disappearance of the civil jury trial, and why should we care? I think we should care deeply about it. In the criminal context, you see that one example, which is a very personal example, that the jury was able to reach what I think was a fair and just result that reflected the community values and so forth. In the civil case as well, I think it's very important for people to feel vindicated if they've been wronged and have an opportunity to tell their story. Now, well, why is it going away? You know, arbitration may be one, but our firm does complex civil litigation, mostly mass tort work. And I can tell you, I think that two of the biggest drivers why we're seeing diminishing jury trials is the threat of a nuclear verdict. You know, you are seeing verdicts today on a daily basis that are truly extraordinary. I remember when I first started practicing, this is 30 years ago, and I was doing automotive product defect work. And if we had a $1 million case in those days, it would be a catastrophic brain injury case, you know, a horrible burn. I mean, the worst type of tort injuries you can imagine. And that was a $1 million case, you know. And now I know we've had inflation, but that case today could be worth 30 million, 50 million. You know, we've seen juries in similar cases award 90 million or $1 billion. And so there's something happening in that jury setting today that we didn't see 30 years ago. And that, I think, is a concern. You know, you're rolling the dice anytime you take a jury trial today in a complex civil case. And that's a difficult pill to swallow for a lot of corporations, you know, because they know that headline is going to be out there in the news. And we have social media today that can quickly take that and generate thousands of cases, influence future juries. You know, social media is being very adept today. The plaintiffs' lawyers, I have to hand it to them, are very creative, that social media and even lawyer advertising has changed. 30 years ago, lawyer advertising was, if you've been injured, call 1-800. It was to help injured people find lawyers to represent them. Today, a lot of the ads that we're seeing, particularly in areas where there are bellwether trials, are clearly intended to influence the jury. You know, ads that say, a jury has found this defendant guilty. Okay, you have guilt in civil setting, but they use that in ads because they know it resonates with jurors. They make them think the defendant has done something bad. And then they'll say, has found them guilty of $90 million. Okay, that's clearly intended to be an anchor to tell jurors watching that television ad, when you go in the jury box, people just like you have found $90 million to be a normal thing. And in the billboards, I now live in Florida. We moved to Florida during the pandemic. It's really remarkable. You can't go a mile down the highway without seeing an ad of a guy holding up, you know, a check. They don't look injured. They all look like they just won the lottery, saying, Dan got me, you know, $3.5 million. Dan got me $7 million, you know. And so anyway, those, I think, are intended to desensitize us to bigger numbers. And so we're seeing that in the jury. And so I think, yeah, we're having diminishing jury. The other is because of the unpredictability of the jury system today. You know, some of our clients, you know, you take a look at some of the mass torts that are being advertised on TV today. I think in the ovarian talc cases, I think Aviva Wien from J&J will be here, but I think last year I gave a keynote and I mentioned something that in the ovarian cancer cases, they had won, it's not going to be exact, but it was something like 17 out of 18 cases or 18 out of 19 cases. But the one that they lost was $2.12 billion in the city of St. Louis to roughly 20 women plaintiffs. You know, in the Roundup cases, if you look, there's some huge verdicts, but Bayer's winning about half of those. So what do you do when you have a jury system where you have two cases that are essentially identical? Identical product, identical injuries, identical exposures, and in one jurisdiction you get a defense verdict, in the other jurisdiction you get a $90 million verdict. I mean, there's just no predictability to what's going on, and that also leads to the defendant's questioning, do I really want to roll the dice here? Because I don't know what's going to happen. And if the lightning strikes, it's going to be bad. So I don't know how we deal with that, but I'll just close with, you know, from the plaintiff side, I think that the diminishing of the jury system is a bad thing because tort law tends to always move in one direction. It always tends to ratchet towards expanding liability, creating new liability. And every once in a while, we'll go in and I'll work on tort reform and we'll ratchet it back a little bit. But by and large, tort law is always progressing forward, and that only happens when you have jury trials and take cases up on appeal. So, anyway.
We'll have to move faster if we're going to get through our next three topics. And I'm going to take a little bit of moderator from Arizona's prerogative as we jump into the ABS and non-lawyer ownership discussion. I'll note we actually have the chairman of our ABS committee here this weekend. I'm not going to point her out, but if you want to know her, I'll introduce you later. Arizona has been experimenting in this space probably the longest, and it's a very interesting space, the non-lawyer ownership of law firms. It's created these alternative business structures. And I asked a few folks for sort of some feedback on how that's going. It sounds like there's a lot of market influence right now. There are different structures cropping up to deal with, for example, how does AI use in the legal field improve services to clients? And can there be new structures set up to take advantage of the use of AI? Another person pointed out the legal field is one of the few, perhaps the only industry that has avoided deregulation, and that may not be for the best when the average American cannot afford to hire a lawyer and cannot access the system. So that's one of the I don't know, pushes toward the ABS kind of programs in different states. One of the folks who serves as the compliance attorney for a significant structure in Arizona, his view is that non-lawyer ownership is not going to cause or necessitate changes in the civil justice system. But one of the points that he made is there's a lot of fear about how this is going to work in a patchwork of states, and when you have potentially national firms or structures that are cropping up, and they have different regulatory structures state to state. His view is what happens in Arizona should be concerned with Arizona. The committee should not be concerned with whether or not a compliance attorney who's situated in Tennessee is complying with Tennessee's law. We should only be concerned with, are they complying with Arizona's structure? But that's a question. Should the Arizona committee consider a complaint against a compliance lawyer who functions in Arizona properly but is not functioning in Tennessee properly? That's a question for the committee. That's a policy question. But so those are some of the issues that we've seen cropping up. It's a very vibrant area. It's a very interesting, exciting, and perhaps cautionary area in Arizona. Bob, I'm not sure what you think about the ABS process.
Well, let me take a step back first. The Conference of Chief Justices had a task force looking at the unserved needs of people who end up having to use the court system. Overwhelmingly, they see default judgments because people don't have representation, they don't know what to do. Unrepresented litigants are a huge issue. And so this task force was looking at that issue and trying to come up with solutions. It was chaired by then Oregon Chief Justice Tom Balmer. And what one of the solutions was a technology solution, that maybe courthouses should have these kiosks that, like TurboTax or something like that, allows you to put in enough information so that you can get some guidance in it, and there'd be also some people designated for purposes of guiding them through the process. And while that sounded promising, of course, there are budgetary issues, and that's probably the biggest reason why it hasn't gone forward anywhere. So then you look at alternatives, and the alternative business structures of Arizona has been pioneering in that respect. I believe it started in 2021. And what you have is something that allows non-lawyers to be part of the law firm, to participate in both its profits and its management. And of course, that raises certain issues. under the Arizona model, I believe they're still obligated to follow the rules of ethics that apply to lawyers. But they have different interests. As lawyers, we are officers of the law. We are supposed to operate in the public interest, and that may not necessarily be part of the purpose behind some people getting into these alternative business structures. And so this becomes a concern if you put the profit motive ahead. Earlier this year, the Arizona Supreme Court approved KPMG, the Big Four accounting firm, to get into the legal business. They've been doing this globally for a number of years. As they boast on their website, they have 3,800 legal professionals in 84 countries. And KPMG Law US launched in February of this year. Arizona is now the first state to permit them to operate in that state. And one of the things that they boast about, which also, again, spills into another of our topics, is that they use AI to be more efficient. And we all, as we will talk later, know that some of the problems AI presents. And what they state as part of their mission is that they seek to complement traditional law firms through high-volume legal tasks and call themselves the future of legal operations. That may well be true. And particularly the AI part of it. But the fact of the matter is that there's something different that's occurring there. It may not be something that we could hold back, but it is a different kind of law than I've practiced for 47 years. And we have to make the adjustments, both in terms of our rules that govern trials, as well as our rules that govern our ethics.
I think what I've read about non-lawyer ownership of firms, it seems to be that the reason that I read that it's being promoted is because of access to justice issues. There are many areas, smaller value claims, immigration, landlord-tenant, people just can't get a lawyer. But to me, this idea that allowing for-profit entities to invest in law firms is going to fill that void is naive. I think it's silly. If law firms are not, why aren't law firms going into these areas? Because they're not profitable. So do you really think a for-profit entity is going into those areas either? No. They're not going to go into areas where law firms are not making money today. They're going to go into mass torts, and they're going to follow the money, just like law firms do. So I think that this is a real need. I think that the solution should come from someplace else, maybe looking for certified paralegals in these areas where there is an access to justice issue. I go to nurse practitioners. Frankly, they're just as good as the doctors I see for most of the things that can be done. So I think we do need to look for some experimentation in our system. I don't think that non-lawyer ownership is going to solve the problem. And I've written about this. I chair a committee of the International Association of Defense Counsel, and we filed comments opposing these types of issues for really two reasons. One is, and they both stem from threat to lawyer independence. One of them is the direct threat to lawyer independence in terms of exercising independent judgment to zealously represent the client. At some point, if a case drags on too long, the corporate entity is going to say, hey, we've invested so much money in this case, it's gone on for so long, we need to wrap this up, okay? That puts the lawyer, and these are the same kind of things that we talk about later, maybe with third-party litigation funding, that you put when the golden rule, the person with the gold is ruling, is it possible to both have a client who's the injured person and still be beholden to somebody that's paying the fee? And then the other is, frankly, lawyer independence about, we went into the law, many of us, because we want some flexibility in terms of what clients do we represent? How much do we want to charge? Even, do we have to return to work? And do I have to wear a coat and tie to go into the office? Those are all things that, as a partnership, every firm has its own culture. And our culture in Kansas City-based firm is different than a New York City-based firm. But there are reasons why people go to work for one or the other. And I think if we had corporate law, if law became like the HCA, and we all joined, a law corporation that dictated our return to work policy, our dress code policy, which clients we could represent, I think it would drive people out of the law profession. I think it would take away one of the things that really makes our profession special.
Well, I hope we'll get a chance to continue talking about it. Arizona is certainly taking the lead on all of those kinds of experimentation. We also have non-lawyer certifications, both paralegal and legal paraprofessionals that can represent clients in certain cases. So we just are the Wild West. That's what's going on out
I
there.
mention one thing? It may be interesting, and I certainly am not on the plaintiff's side, but there may be, and Nate is here, I'd be happy to get your thoughts, some difference of opinion within the plaintiff's bar. So there are some that are advertising on TV. One, for example, that's on TV every time I turn TV on, every time they go to commercial, that I suspect if they could sell shares in a firm, those lawyers would go from being worth several $100 million to several $1 billion. So there may be some plaintiffs' firms that could literally cash in with generational wealth for 100 generations to come if they could have non-lawyer ownership. On the other hand, your more lower value billboard lawyer, local lawyer doing auto accident cases really probably faces the threat of going out of business. Because if there are people that can scale up and run this, you're going to put the smaller plaintiffs' firms out of business.
So I'll just say that we have the exact opposite example. In Arizona, we have a local accident firm whose new compliance lawyer was a senior partner at an international law firm, and he left that to go be compliance lawyer for a variety of reasons, but one of which was the financial benefits from the accident firm.
My understanding is that most plaintiffs' lawyers do oppose this kind of thing, that they like their independence and they like to think that they're part of a learned profession, which goes out the window when this occurs, and they like the fact that they can develop skills. And part of my reaction to what Mark said earlier, why are juries coming up with different verdicts on the same issue? Part of it is the skills, the experts that are brought in to those particular cases. We've all seen cases where someone has taken a winnable case and lost it because they did something that you wouldn't have done. And that applies both to plaintiffs and defendants. But the idea that essentially this becomes essentially a corporate profit center, I think is very much against the idea when plaintiffs' lawyers like to think they're advocates for people, and I think that defense lawyers also value their independence, and so there's been resistance. There was a resolution a few years ago before the American Bar Association, and although there seemed to be a lot of momentum behind it to support alternative business structures and support from a number of former ABA presidents, it was defeated by the body, and I think part of the reason for that defeat was this idea that we are a different entity than most other professions.
All right, so AI. This is a fun topic, and I will just say, as a judicial officer, we all probably are kind of grappling with what do you do when something comes in your inbox or is prepared for a case that you're working on that is unquestionably some kind of AI hallucination or problem. And I'll just say I have two recent examples. One is mine. I issued a memorandum of decision in a case that an entire section of a brief clearly was hallucinations. There were a number of citations, none of which said what the brief purported that they said. None of the quotes existed in any case anywhere. Some of them pointed to actual cases, none of which were actually the subject of that brief. And our decision was to, in the decision itself, indicate we'd be sending a copy of it to the state bar for disciplinary proceedings as they saw fit. and we used the text of the decision to describe the problem. So we didn't go outside of that decisional process to pursue anything. We didn't sanction monetarily, but we did send it to the bar. On our federal district court in Arizona, just in the past couple of months, we had a judge who did, I would say, a step further and issued pretty significant sanctions, revoked a pro hoc vice certificate for that particular attorney who represented folks in Social Security cases, and issued basically a series of monetary sanctions, and then required that attorney to file copies of the order with other judges in her cases. So there are certainly some extreme directions folks can go. I'm curious from our practitioners what your thoughts are on, again, what is the role of the court in policing this, and what should that look like for us?
Right. Well, courts have taken a variety of approaches to this, but it's clearly a problem. Once in a while, you will see. I'm an appellate lawyer, and I read briefs all the time, and you will see something that looks, wow, this section is completely different. And it reminds me once, for a while, I used to teach legal ethics, and one alternative to the exam is that people could do a paper. And I got this one paper from a student that just seemed so polished compared to the way that he spoke about things in class and everything. So I went on to Westlaw, and I put in some phrases from the paper, and I discovered what he'd done is rather skillfully knitted 2 law review articles together to do his paper in a legal ethics class. So this discussion reminds me of that. And what you see is you look at it. Sometimes I just did a brief last week in which I was responding to someone who cited a real case, but his point was not in that case at all. And I suspected AI being it, and sort of subtly suggested as much by saying that the only possible explanation would be something like AI, and we'll see what the judge reacts to that. So, what have we seen as rules that judges have set up on this? One is mandatory disclosure. Northern District of Texas, there's a standing order that requires a certification that if AI was used, it has to be disclosed. And some of these mandatory disclosures even say what sections of the brief have to be identified. There's detailed disclosure that is that, and even says what program they may have used. In Illinois, the federal judges require disclosure, but the Illinois Supreme Court has ruled that the rules of ethics are sufficient and they're not going to come up with a special rule. There's verification accuracy checks, so there's a certification that if you may have used AI or not, you have read the cases, you have checked the sites, and you are verifying, just as you are supposed to do when you sign a complaint, that you have a reasonable basis for everything that's in that brief. There's some courts that require what they call a Rule 11 verification, that essentially you are verifying under penalty of Rule 11 that you have indeed made sure that this brief is your product. And we've seen not only have lawyers, and there's a prominent example just in the past week of lawyers using AI, but we've also, in the last 2 weeks, for the first time I noticed, there was a judge who admitted to using AI in an opinion that cited cases that didn't exist. In Montana, there's a judge who has done an absolute prohibition on it. You cannot use AI, and if he discovers that you do, you are going to be not only suspended from his court, but referred to the bar. There's restricted uses. The Western District of North Carolina has a standing order that bars general purpose AI for drafting, but allows use of approved legal research basis, now that Westlaw and Lexis also use AI. There are monetary penalties. There's clearly also a loss of credibility with the judge, and that, of course, is the most important thing a lawyer needs to maintain. Judges have disqualified counsel, as you mentioned, and there's also often professional discipline. It's an evolving landscape, and it really does require, we always check every, despite the fact that I may have read the case, it's my own research that I've written in the brief. Before I submit the brief, I go through it one more time to make sure the pinpoints are correct, everything is exactly right. That's what I frankly expect of lawyers. Now, we've talked about this issue, but let me raise one more issue that also the Federal Rules Committee, Evidence Committee, is looking at, and that is deep fakes. The kind of evidence that's coming before you can be created by AI in such a way as to give you bad information, give juries bad information. And that's a problem that we're only beginning to get our arms around.
This is a fun panel. This is, I was really lucky. I just had an associate. I came up with an idea, which I may share with you after I vetted a little bit, to do a proposed federal rule on what do we do about this AI issue. And then just looking at the memo he gave me 10 minutes before we started today, I've learned a little bit about this, and thank goodness he did it right before this program. But I think Bob's done a remarkable job, as always, just kind of going through what the courts have done. And I think in terms of where I come down, I don't use this technology, but I don't think a prohibition is a good idea, because there may be efficiencies. When we talk about access to justice, there may be a use for this technology to bring down cost and help that access to justice issue. And I think, like a lot of things, there could be a tremendous good out of this technology if it's used responsibly. So I'm not a fan of prohibitions. I'm not a fan of disclosure either, because just disclosing I used AI by itself doesn't solve the problem that we're talking about. It puts the burden on the other side to go check and make sure that the sites are all accurate. That's supposed to be the lawyer's job, signing the paper. The other thing, too, is a disclosure, to me, would be stigmatizing in some way and may discourage use of this technology. Again, frustrating if our policy is to try to promote access and reduce the cost of the legal system, then a disclosure rule that could create a stigma over the use of this technology or bias against the attorney using it, to me, is probably not a good idea. And I suspect a lot of those may be smaller plaintiff firms trying to gain efficiencies and so forth. And so, maybe the bias would be felt disproportionately on that side of the V. So I'm not a fan of disclosure for that. I think that the accuracy check is a fair. That's what we, like you, this is how you do your business. And I think we all should. I mean, when I get a brief, even when an associate works on it, I pull every case. I read them, make sure they say that not only the cases are there, but they say what the brief is saying that they attribute it to. So I think that's just responsible lawyering. So if we need a rule that says you need to be responsible lawyers, fine. But I think that's probably the way that we should go, rather than disclosures or prohibitions.
It's certainly an interesting area, and from a lawyer ethics perspective, and we have ethics rules that require lawyers to sort of be up to date on not just the law, but technology. And so I think as judges who have lawyers who are going to be exploring efficiencies and that sort of a thing, we also should probably take on some of that obligation to be at least familiar with what's out there, so that we know both how we can do our job the best, but also spot these issues and contribute to the production of rules with regard to them. I'll just say as an aside, I've been kind of learning how to use this because I've had some opportunities to speak in the area recently. And there are some remarkable tools out there that do not present the issue of the hallucinations or the fake sites. This is not an endorsement. I am not getting paid by them, but Google Notebook has some really fascinating tools that I test ran this past week on a case that I had already reviewed the briefs and the record, and we had prepared, for conference and argument and everything. But I ran it through Google Notebook. This is a place that you can do a closed universe. It's not going outside of the materials that you provide to it, but you can provide the briefs and ask it for a case summary. It gave me a remarkable case summary that took the two briefs, which were okay, but it did a synthesized very well formatted summary. And then I had it produce a podcast, and it had a conversational two-voice podcast with jokes that described the case, including a kind of thorny confrontation clause issue in a really interesting way that I could listen to on the way home. So there's some tools out there that I think give us new opportunities to get into cases and to do our job well, and for law clerks to do their job well, but boy, do we have to be careful about it. And the only way to be truly careful is to learn more about it. So,
But it is very tempting.
It is.
I've got to say, I have a brief that's being filed today. It's a reply brief. So I looked at the responsive brief. I read it. I made my notes about the points that I thought I should respond to and that sort of thing. And then out of curiosity, just the AI that's part of my browser, I said, what are the main points of this brief, just to summarize it. And I saw that it hit most, though not all, the points that I identified, and that was interesting to me. There were two articles in yesterday's New York Times, one a column by Maureen Dowd and one a news article, about how AI is improving and getting to be smarter than us and how it's going to eliminate a lot of things that we do on our own these days. And clearly a lot of expressed concern about that development. But the question then is, how can it be used as a proper tool and when is it improper? And that's part of what we have to figure out.
Agreed. All right. The last and most exciting, well, I don't know if it's most exciting, but public confidence in and respect for the judiciary. Is it decreasing, and if so, why, and what can or should we be doing about that?
The National Center for State Courts does an annual poll on public confidence in the courts. And that poll over the last 5 years has shown a complete decline. Not as bad in state courts as in federal courts, but still a decline either way. And as it goes deeper into those questions that it was asking the respondents, it discovered that basically, and probably no surprise, that their views of the Supreme Court color their views of all courts. And to the extent that the court is doing something that's either not transparent or not popular, or they've heard criticisms that may or may not be true about what was just decided, they react to that and they paint all courts with that. It's not unusual for people to do the same thing with politicians. You see one prominent and you say they're all like that. So this is an issue for the courts because public confidence in the courts is the coin of the realm. It's what explains to us why people use the courts, why they think that they can get a fair shake there, why they look to the courts as usually also better regarded than the political branches of government. And so it's a real problem. It requires education. Most people really do not know how courts operate, and it's remarkable to me. There's been polling forever about the three branches of government, and people often cannot name all of them. They can't identify even a single judge who isn't a TV judge, things like that. And this is a problem. This is a problem because if our courts are going to get the budgets they need, get the respect they need, people are going to obey the rulings that they issue, public confidence is essential.
I agree. I've always thought that when we hear about are people losing confidence in the judiciary, most of those seem directed to the U.S. Supreme Court and what's happening there in terms of decisions or even just, personal trips and things like this that judges have taken. I don't think, in my opinion, that it trickles down to you folks. I think most ordinary people think our frontline judges are doing a great job and are immune from that. Maybe state Supreme Court races kind of gets a little closer to people wondering about, their confidence when you see huge money on both sides being devoted to judicial elections. And I think maybe there is a problem there, because on as a civil defense, there's probably 4 or 5 courts in the United States where I'd feel pretty confident that our side would win getting before a particular court. There's other 4 or 5 Supreme Courts where I think the same case we would lose. And it's because of who's wearing the robe. And that's a fact. And I think that's a problem for our system. Now, what do we do about that? We're not going to get rid of judicial elections. I don't think. The public seems to like that. They like to be able to elect their judges. So, I think in terms of solutions to promote more respect for the judiciary, I've got 3 things that I put. One is the judges that sit at the top that have public visibility just need to be more conscious of that. I think more careful about some of their personal decisions. The other is jury trial innovations. Like we talked about, for most ordinary citizens, their only interaction with the court system is when they're jurors. Most people are not plaintiffs in lawsuits. They're going to be jurors. So I think we look to jury innovations, and the National Center for State Courts has been great on this. But things like one day, one trial, that make it easy for people to serve. You call up the courthouse. If that day doesn't work, you give them a different day. And Arizona has a very innovative lengthy trial fund to help pay people more, because it's asking a lot of most ordinary folks. I think when I come into town, I stay at the Hilton down the street. Okay, from the people that check me in at the front, to the people that are cleaning the room while we're here, to the people that may serve us breakfast, they can't afford to be on a jury trial for a month. They're not going to be able to pay their bills. And so Arizona has this amazing lengthy trial fund to help give those people extra support so that they can serve on juries without fear that they're going to not be able to buy food, pay their rent, pay for their car payment, and so forth. And I think that's something that more states should look at. The more opportunities we have for people to serve and take away the things that make it where they can't serve, whether it's they can't afford to serve, or it's inconvenient, or they can't take that much time, there are innovations that states are doing to solve that. And I think that your state should look to do more of that. And finally is, for all of us, to have conversations, and we talk to people, whether it's op-eds or so forth, to just explain to people a little, have more civics in our school systems. And I know that there's an iCivics program the IADC is very involved in, but those types of things to educate our young people, I think are critical as well.
Yeah, so I'll just mention a couple of other things that we do in Arizona. I think a lot of states do this, but I think it's a valuable tool to exactly that last point that you made, Mark, which is introducing more people in the community to what our job looks like. So 2 times in November, I will be sitting with a panel of my court out away from the court. One will be at a local high school and one will be at our local law school. And we will hear a regular case, a case that comes before the court, and the attorneys agree to argue in front of the students. And after the case, after the argument is complete, we stay up and take questions from the students, law students or high school students. And obviously we don't speak about the case itself, but it's an opportunity for young folks. I especially love doing the high school programs. These are in a lot of the communities that we go to. There are young students in these rooms that have never spoken to a lawyer. They certainly have never spoken to a judge. And this is an opportunity for them to have that conversation with both the lawyers and the judges, and to think about this as a future, but at a minimum to see the system working in a positive way, whereas maybe what they've heard about from friends or family members is not such a positive way. The other thing I just would encourage everybody in the room to think about is, do you write in a way that makes whatever it is you issue, an opinion, an order, a decision, accessible to the average person? Is your language accessible? Can somebody who is wanting to find out what your court has said on an issue, and they just Google and find some public document on Justia, can they read what you wrote and have any idea what happened in the case? I think that should be a goal for all judges to improve now that we have everything online and members of the public are able to go find the ruling on Bob's latest appellate decision. would they need to go to Bob to understand that? I think we should all seek to be more accessible in our writing. And then lastly, we have a member of our Supreme Court here. You can certainly ask him about the AI use that the court is using. So now every time an opinion comes out from our Arizona Supreme Court, they not only issue a press release that the justices, actually I don't know if all of them are involved in or just the author, okay, all of them are involved in crafting, that explains what the actual decision is. So beyond the language of the opinion itself, there is a press release saying, so this was the issue in the case and this is what happened. But they've gone a step further and created an AI-generated video. The transcript, the script for it, is pre-prepared. This is not, they don't just kick it to some AI and say, what would you say about this case? They dictate it. But it's more accessible, so somebody who's not going to read the press release will watch the video. And so it's an effort that the Arizona Supreme Court is making to ensure that when the public hears about perhaps a very controversial decision, perhaps a 4-3 split decision that comes out, they can perhaps better understand what was at issue in the case and not just sort of the top line subject matter. This was a murder case. This was a case on a difficult public policy issue. So those are some thoughts of things for you to...
If I could mention one other aspect of this public confidence question. I was on a panel a decade ago in which a Chief Justice of the Minnesota Supreme Court said that one of their problems was that fewer and fewer members of their legislature were lawyers and had any clue how courts operate. And so as a result, she started this judicial ride-along program in which they would invite legislators to sit in on trials and see how they actually operate. And she said it had remarkable results. I don't know if they still do it, but it was fascinating to hear that.
Mm-hmm. So we're going to be jumping to audience questions here soon, and I see there is no one at the microphone. So if you have a burning question on any of these subjects, please start lining up, and I'll just, Mark, was there anything? Oh, excellent, excellent.
Right.
I'm actually, Michelle.
Good morning. Thank you to all of the panelists. I will start by saying this is my real voice. I am not AI generated, and my questions are derived from my own listening to your comments. So thank you all so much. Starting first with the AI, and I have a question for each of your topics. Can you speak to self-represented litigants and their use of AI? And also you had mentioned about disclosure. And I think that if there were a disclosure rule, we would all have to admit to using AI because it's in its simplest form of doing a Google search. We're using AI. So the disclosure combined with our rules of ethics. And I think that there may need to be, and if you can speak to this, some modification, if you will, on our rules of ethics, because even if someone were relying on, and you mentioned the example of the Google software that is very helpful, if the court in a way were to accept that, that becomes an endorsement or form of advertisement that we as judges are embracing, which would run afoul of our rule of ethics. So if you can speak to that first topic, and then I have others for your other areas that you've covered, unless you want me to go through those as well first.
Let's go one at a time so we don't forget. Did either of you have any?
You make a great point. I'm going to write that down because that the pro se litigants, some of the reforms I've seen are to deal with this through Rule 11 or other reforms. But if you're not a member of the bar, then these other rules aren't going to apply to you. So, in sending a bogus or fake pleading to the bar authorities isn't going to work if it's a pro se plaintiff. So, I really appreciate the question because it does say that maybe some of the tools that courts have looked at to deal with this aren't going to be satisfactory. And I suspect those are going to be the people that will use the technology, one, because they're non-lawyers and this spit something out that they can use. But having said that, there still needs to be a responsibility, I think, to the courts because I worry that particularly maybe in state courts review, I don't know what your resources are. At the federal courts, you have 2 or 3 clerks and people that can pull every case. A lot of state frontline trial judges probably don't have that. And my worry is that if you get bad information in, that there's always a risk that bad information comes out. And so I think even if it's pro se or represented by, you know, some big New York law firm, it still is incumbent on whoever's signing that to say that what's in here is not a hallucination, and the cases say what we're describing them as.
And while, you know, you can understand a pro se litigant who can't afford a lawyer, doesn't really know anything, using AI to try to at least approximate that. The fact is, to the extent that they know it, that they've done this not in good faith, that they don't answer honestly a question about that. The courts, besides the rules, as Mark mentioned, Rule 11 and that sort of thing, courts have inherent power to discipline those in front of them. They control the courtroom, they control what's going on, and so therefore they can fashion an appropriate remedy. And I would urge you to make use of that.
The other one was about the non-lawyer ownership of firms. And you talked about how it's for profit. What about the not-for-profit model? Is there a not-for-profit model? Because even today, there are a lot of people who are relying on not-for-profit associations who, of course, don't have enough resources to represent everyone. But the same model that you had mentioned in Arizona, is there a not-for-profit model? And what are your thoughts on that?
Yeah, so Arizona's model includes a significant number of nonprofits. It's not exclusive to a for-profit model.
And lastly, you mentioned that there's a disappearance of civil jury trials, and I'm actually seeing an increase in civil jury trials, in part because of the public confidence or the lack thereof in judges individually. We're not a panel. The trial judges is just one person, one judge's opinion and thoughts. And so there's a move toward having increased jury trials. The belief that, hey, now we'll have access to someone other than just one individual determining our fate. And I'm not sure if that's due to the increase in jury pay. They've increased jurors' pay in New York. But if you can speak to the increase, if you will, of civil jury trials, not just in the criminal context, but civilly, we're seeing that happen in New York.
Well, you know, that's very encouraging to hear, really.
I don't know, you know, I'd be curious to see if 3 years from now, what effect COVID would have had, because the courthouses were closed for some period of time, and so that may be a confounding factor. But yeah, I'd be encouraged to see more jury trials. I think because we're just a few years out from COVID and courthouse closures, whether any of that's attributed to some catch-up of cases that were backlogged.
And I think they've also moved toward having, what do they call, professional jurors, if you will. It's a group of people who like being on juries. They welcome the summons in the mail. Any thoughts on that, whether that would be an increase or in juror selection? That no other state has done that?
Yeah, you know, professionalizing
Yeah.
jury services, I think, is problematic. It loses the basis that caused it to be part of the Constitution, that you want people who are not jaded, who are not, who said, oh, gee, I've heard that before in this courtroom, that sort of thing. That's part of the reason why a juror looks at things somewhat differently sometimes than a judge.
I got to share a funny story. This is funny. Years ago, my mom's been retired for 20 years, but she got a jury summons in Fairfax, and she didn't want to go. So she showed up, and the judge said, is there any reason why you shouldn't be on a jury? She raised her hand. The judge said, what's your reason? She said, my son is counsel to the American Tort Reform Association, and I think there's too many lawsuits. She thought that was her ticket out. The judge looked at her and said, thank you for sharing that, but this is a criminal case, and you're staying. I'm sorry.
Thank you. Thank you.
My question is somewhat of an offshoot of her last question, and that is, do any of you have any insight or experience, or are you aware of any studies that have been done on what has started off as a civil jury trial that end up in arbitration or mediation? In other words, is there more an inclination by attorneys when they find out these circumstances you all have been talking about in the cases ending up being resolved by mediation or arbitration?
I've got no experience with that at all. I'm an appellate lawyer. Either appear in the U.S. Supreme Court or often state Supreme Courts, and at those points, most of my issues are constitutional. Those are not subject to mediation.
Yeah, I think same. I haven't had that experience.
Thank you.
Thank you. My question, I guess, goes back to the topic of alternative business arrangements engaged with the practice of law. It seems to me that there are two distinct strains of issue there. One is the monetization question, and then separately is the mixing and intermixing of professions question, which are, I think, distinct from one another but could overlap. The monetization piece, I think, is easy to understand. You could find private equity, you could find individual investors, you could find a structure where people say, we can monetize this like we can monetize anything else, and we'll find a profit in which to engage. I'm far more interested, though, in your perspective from the practitioner's point of view with respect to the advisability of, for lack of a better term, intermixing professions. The KPMG model tells us, as do a lot of firms in Europe and Asia, that you can put tax advisors, accountants, business professionals, lawyers, and put them in a single silo, and it works. But I'm interested about the maybe more provincial view of the lawyer in this country. Warren Buffett, I think, was the one who told us that the law is, in his mind, the last medieval guild. It's the only organization that sort of self-polices itself. It decides who can be a member. It decides who gets ejected. It decides what all the rules are. And in the United States, you have the phenomenon of 51 individual fiefdoms beyond that, right, that are jealously guard what it is to be a member of the bar. Do you think there really is enough of an upheaval movement from the grassroots perspective of practitioners that they want any of this? That's my question.
I think they don't. I mean, I know the IEDC has filed comments with DRI and FDCC and LCJ saying the defense side does not want non-lawyer ownership of law firms. I think the plaintiffs' bar has taken that. The Florida bar looked at this about a year ago and I think came to a unanimous conclusion that they didn't want to go down this route. The threat I see, and this is maybe looking out, is where this goes. And I think there's a big difference when we're talking about the nonprofit that you have in Arizona versus mass tort firms that are moving in just to make money. Because I think that over 30 years, so this fits into third-party litigation funding that we're seeing pouring in, billions of dollars being poured into the legal system. I think that there could be some on that side that say, the end game here is to have third-party, rather than being third-party investors in firms, that they just buy up the firms and they're running the show, and then eventually that they can buy up claims. We saw with Cisco versus Burford that there was an assignment of claims to the funder. So, the ethics rules don't allow this now, but could we be in a place 30 years from now where we have law corporations that are able to buy and sell claims, and they buy up somebody's claim and they bring it on their own behalf using their own lawyers, and they make the money for it? I don't know, but it's a futuristic view. Could somebody get in a car accident case at some point and sell that claim to a firm that would then litigate it on its own and make the money on its own? I think that may be where some of the investor community would like this to go, where law claims become exchangeable like mortgages. I don't know, but I think that could be something we have to be mindful about or guard against.
I agree that we have to watch that very closely. In some ways, this is an expansion of the insurance company model where they have captive law firms that basically do this and are basically ruled by the insurance companies. The defense lawyers who are part of that don't like it. I don't think anyone who is a lawyer who thinks of themselves as an independent thinking person looks forward to that.
All right, we're down to our last few minutes. I'm going to try to get you both in. All right.
All right, thanks. I was, with respect to the public perception of the judiciary, I sit in a bankruptcy court. Most of our hearings are remote. And I'm curious as to your thoughts on remote hearings. There's pushback from the Administrative Office of the Courts towards not having remote hearings, and that may flow from the Supreme Court not wanting cameras. Your thoughts, and does that change the perception, having access both for media and the public to see what's going on by courts having remote hearings?
You know, I have mixed feelings on remote hearings. I've done them with one-judge courts where I thought they've worked rather well. I've done them with en banc federal appellate courts where we had 19 people arrayed on my screen, and I thought it was terrible. I think that, you know, the idea that the public might be able to watch this without having input and that sort of thing is an interesting idea. I haven't thought about that, but it might also expose the law in the way that we have found that televised trials sometimes expose the law, even though when you take excerpts from it, they can be misused.
Yeah, so we live stream our arguments and have the ability to take remote arguments, which I think is important in a state that's big and has rural communities, and it can reduce the costs for folks. Having said that, I have disliked all of my remote argument experiences from a effectiveness standpoint, but I think it's good to have the access, and I think it's particularly good to have the ability for folks later to come back and watch a proceeding, see what the judges are like, see what the interactions are like. It's an interesting area.
Yes. As it relates to the ABS litigation, what have you, has anyone ever considered the dangers in who's the client? Are the investors the client, or is the plaintiff the client as it relates to the law firm? And who's your loyalty to, and the issues that brings up?
So I just will say that's accounted for in the legal regulatory structure of the ABSs. The client's defined as the client. And that is why in Arizona, the compliance attorney is probably the most important piece, is that attorney is responsible for and sort of signs on the dotted line for all of these kinds of requirements to ensure that happens in every case, that the client is the client, that the ethical rules that govern lawyers and lawsuits still govern those cases. And I can tell you in Arizona, we've already had one rejection of an application for an ABS and one non-renewal or withdraw of a certification for ABS based on some of these issues. So at least so far, arguably, the system's working to weed out those structures that are not meeting these minimum standards. So for whatever that's worth.
I'm curious, has it opened up access in the underserved communities or on like landlord-tenant? I mean, is it working for those things?
Yes,
Yeah.
KPMG is, in fact, yeah.
Yeah.
I'm outing her
I mean,
now.
I'd love to hear it, yeah.
Judge Foster on my court is the chair of that ABS committee in Arizona.
Hi, so yes, I would say that it has opened things up. Not as much as I think we'd like at this point. For a lot of the issues that you've already identified, there are people with mass torts firms that are coming in and they see a big dollar amount. But we have seen some really interesting sort of innovative partnerships. For instance, the one that I always highlight is we had a nonprofit who works with veterans and provides veterans services. They partnered with a lawyer up in Prescott, which is a more rural area of our state, and to help find pension funds that veterans are eligible for that they don't even know that they're eligible for. So there are some interesting partnerships that are happening now. And I would just add that one of the purposes of the ABS structure, you know, there's again a lot of talk about the money to be made, and there are a lot of people who think there's a lot of money to be made. But one of the main purposes is that our Supreme Court was seeing that the middle level firms and the solo firms in our state were kind of being pushed out by the larger firms who had resources. And so this was meant to be a situation where you could have someone invest in a mid-level firm or a small level firm, and then they would have the resources to bring cases that they wouldn't otherwise be able to have, because, you know, from a plaintiff's perspective, what we're seeing is you have those big firms that are willing to take big dollar cases, but, you know, the smaller dollar cases, sometimes people just can't get justice for. So we're seeing all kinds of issues, and that's what the committee that I chair is about, is regulating in a way that we're not too constrained, but at the same time, making sure that, you know, those ethical rules, knowing who the client is and making sure the compliance attorney is educating their law firm and the owners of the law firm as to exactly what the rules are. And we have had some compliance attorneys who have quit and left these firms because they said, I cannot work with these people. It's unethical. Their funding model is unethical. And so we are seeing that work, so.
We're actually out of time. So final
Is
thought.
there a qualitative aspect to this to make sure that they're not receiving second-class representation?
So we are working on some of that. We have had complaints, and those complaints have gone to the bar, because that's who regulates the attorney aspect of it, or they come to our committee, and then ultimately the bar will take action. We have seen sanctions from compliance attorneys for, you know, not complying. So the system is working, but again, you know, it's going to take some time to really see what else comes.
Thank you.
Thank you.
Sounds like maybe a panel for next year.
Yeah, yeah.
All right, thank you.